Thank you everyone for joining us for another Learning Lunch hosted by FormatApproved.com. My name is Brian Johnson. I'm the Senior Director of Online Education with Format Approved, and I'll be your moderator today. Today's Learning Lunch will cover the whys and hows of HIPAA compliance from a layperson's standpoint. We're joined today by Rieger, a certified HIPAA security professional and the founder and president of WEBIT Services, an industry-leading HIPAA compliant technology service and solutions organization in the western suburbs of Chicago. Eric has worked in healthcare IT for more than 23 years, and we are honored to share his insights on HIPAA compliance with you today. Before we begin, some housekeeping notes. Remember that you can ask questions of our presenter at any time by entering them into the chat area during the presentation. We will hold these questions until the second half of our session, and we will address as many questions as time allows. If we do run out of time, written answers to the questions will be posted to our website and sent via email link later in the week. Also, our guests often ask us for a copy of the slides. All registered attendees of today's session will receive an email with links to both the slides and the recorded version of this event. So watch your email inbox for that information. Eric, thank you for joining us today. I think we're going to have an exciting session.
Hi, Brian. Thanks for having me, and I'm excited to be here. And it's definitely a topic that it's a hot-button topic, and it's at the top of a lot of people's radar, especially with the compliance deadline about 33 days away from us on September 23rd. So excited to be here and ready to get going.
All right, great. Well, let's dive right in. So I think a lot of people would need to ask, where does someone start with HIPAA compliance?
Yeah, that's a question we get a lot, just because the laws have changed so much, and there's so much information, and again, there's so much misinformation that's out there. Finding a place to start can be difficult, and where we always like to talk to our clients and prospects and anybody who approaches us, we start with the EPHI, and so we don't get acronym heavy here. The EPHI and PHI stands for Protected Health Information, and what that is it's any identifiable health information in any form, written, electronic, verbal. It's protected by the privacy rule. And with very few exceptions, this information is restricted against release or use without patient authorization, other than the purposes of treatment, payment, or certain healthcare operations. So that's really, in a nutshell, what the security rule is protecting here. So we want to know where that stuff lives. And it can live in a lot of places. You think of your typical, your practice management system, EHR, EMR, all the acronyms for electronic health records, or in hard copies in Word documents, Excel spreadsheets, anything that contains identifiable information, patient information such as diagnosis codes, the patient's name, address, information like that. So what we want to do is we want to know who has access to it in an audit trail. And if there's ever an audit of the facility, they're going to want to know who had access to it and when, because the patient has a right to request that information for up to 6 years from the date of treatment or the date of visit. A lot of times what we see when we're coming in and working with another company on this is, you have unique identifiers. And a lot of times there's a generic account, such as staff or something similar to that, that's being shared by several people in the practice. And what that does is that doesn't allow for a proper audit trail because you have multiple people sharing the same identifier. And if you do go back and have logging turned on and you need to take a look and see who was accessing what and when and why, there's really no uniqueness to that, so you can't pinpoint who had access. And one of the reasons that's important is the snooping that can go on in any type of a healthcare organization. So if a family has other family members that come in and they want their privacy in their records, or so in the case of like in Hollywood, the celebrities that come in and you know, they have treatments performed, and then that information somehow suddenly becomes public, there can be a lot of fines and penalties associated with that. And if the practice doesn't have any type of unique identifiers to be able to do a proper audit log, you know, that can cause a lot of problems. Another thing that you're going to want to do is you're going to want to sit down and map the PHI movement within the organization. So when does it come in? Where does it sit? Where does it leave? Who has access to it? And some of the places that people miss commonly are things like copiers, for example. So almost every practice has a copier in it, and most of the new modern copiers have hard drives inside of them. And even though you're copying a piece of paper, that information may be stored within the hard drive, and when it's time to, you know, replace or upgrade or repair that particular device, that information is actually stored on that drive, so you have to take precautions to protect that or remove it when that device is being replaced. Voicemail is another thing that a lot of times is forgotten, whether you have a hosted voicemail system that goes over the internet or you have an in-house recorder. If a patient were to call in or another facility and leave protected health information on that device, it lives there until somebody does something with it, so you have to be able to have some type of an audit trail or some type of a process to remove that so it doesn't sit unprotected and be accessible by people who shouldn't have access to it. Another thing that you know, you want to look at, especially if there's ever an audit situation, is risk assessments. And if you're using an electronic health records system and you've you know, taken the subsidy money for implementing one of those systems, you attest to core measure 15, and one of the top thing that they're going to look at is you're attesting to having a risk assessment done. So you're going to want to make sure that that's done on an annual basis. And checklists are great, but that doesn't constitute an actual risk assessment.
You're clicking on.
Sorry,
So
a little interference there. Go ahead, Eric.
No problem. The next thing you're going to want to do is have your documentation in order. HIPAA-specific policies and procedures. And a lot of times when we're talking with other organizations, they'll pull out some type of a PCI document or something along the lines of other compliance regulations, and they'll think that that's acceptable in terms of HIPAA, but it's really not. You're going to want to make sure that you have HIPAA-specific policies and procedures documented, and that somebody's reviewing the procedures on a regular basis, because that's what changes. Anytime you're using a specific tool, say antivirus or things like that to protect the systems, if that tool changes, the procedure is what gets updated. The policies themselves are usually pretty vague, and they point to specific HIPAA law, which doesn't, that part doesn't change very often. So it's important to have that documentation in place, again, in case there's ever an audit situation. And then training your workforce. A lot of times that kind of gets left by the wayside, or other training is kind of lumped in there, and people think that that's sufficient, but you need specific HIPAA workforce training, at least on an annual basis. And you need to record that information about who took it, when they took it, and you know, how frequently that is done. And again, that should be on an annual basis.
That's all great information. I like that it combines, you know, that there's technical aspects to this, and there's also administrative aspects as well. And I wanted to add one note about that. I think that example of the photocopier is really great, because you know, the OCR, which enforces HIPAA, just fined an organization, I believe it was $1.2 million for not properly disposing of a copier that contained thousands of health records. So it's really important to keep track of that stuff. So let's move on.
Absolutely, and
oh,
yep,
go ahead.
Absolutely, and with the modern office, you know, the data can hide just about anywhere. You know, we're entering that. You know, the iPad generation, where, you know, there's a lot of mobile and tablet type devices in office. Cell phones are being used for things that they'd never been used for in the past. And it's really important to understand the difference between remote access and actually having data on a device, because once it's on there, and unless you take specific steps to remove it, there's a good chance that it could live there on the device permanently. So, we'll get into that later about what happens when those devices are lost. But, it's really good to work with somebody who has a good understanding of the modern technology and where things could live these days.
So, you bring an interesting perspective to this because you work with a lot of providers. So you have a great insights into what are the vendors actually responsible for? What should providers expect from them?
Well, that's another really tricky situation, and we're going to use some examples here. But what we're finding is, in terms of HIPAA compliance, that a lot of vendors are still not really up to speed on how the laws changed this year. And prior to the Omnibus Final rule this year, the vendors, they weren't really liable. I mean, they should be doing things, the right way for their clients, but there wasn't the responsibility that there is now. It changed from the covered entity being fully responsible because you're bringing that that service provider to the party, as they say, and now it's a shared responsibility. And what we're seeing is a lot of the vendors, they're still operating under the old rules where they think things don't apply to them. And there's a lot of old and bad information that's still circulating out there. For example, like with business associates, it's not just about the paperwork. You have to have the act behind the contract. And some examples of business associates, and this is where it gets kind of tricky because some of these providers don't necessarily consider themselves business associates. Like, let's take a CPA firm that does accounting services to a healthcare provider that involves access to protected health information. That's a business associate. You not only have to have a business associate agreement, but that CPA firm has to be HIPAA compliant in their practices in how they access the data, who has access to it, and what it's used for. Another good example are attorneys. If they're working with any type of protected health information in any capacity, there needs to be a business associate agreement. And one of the things that we've also seen is when we're working with providers and they're looking through their business associate agreements, there's not a lot of people using attorneys who are high-tech and HIPAA trained, and they don't necessarily even know the laws themselves. So you really want to work with a competent attorney who understands and specializes in high-tech and HIPAA compliance when they're reviewing your contracts with your vendors. That's a really important piece. We learned that early on in our service delivery, is that you want to work with specialists who understand your particular market, and especially when there's federal regulations involved like this. Some other examples are your software vendors. Almost every practice uses practice management software of some kind, and those software vendors typically have to provide support of some kind, where you'll have a remote technician coming in. They'll be looking through the software trying to solve a problem for you. They're going to have access to protected health information, so you need an agreement in place, and they have to have compliant practices. Data centers, the cloud, we'll talk about a little later on, some of the complexities that the cloud is bringing to this equation. And there's a lot of misinformation on the data center side. The vendors are confused, or they think because the fact that their employees don't have access and the data is encrypted that they're not part of this arrangement, but they are. And even some other companies like billing services, consultants or contractors, and even shredding services that might have access to your protected health information, you need to have business associate agreements with them. So, the rules changed this year, and we're still finding a lot of the vendors are not up to speed where they need to be, and that's kind of concerning because we have 33 days left until the compliance deadline.
Yeah, there's definitely a lot of misinformation out there, and I like your example of the attorney, because how attorneys need to actually have some expertise in HIPAA because I know that there's a lot of bad legal advice being given right now. We see it all the time, so I think that's a great
Absolutely.
example.
Absolutely, yeah. We've run into it on more than one occasion ourselves, and you know, we tend to surround ourselves with you know, compliant providers as well when we're working with you know, our customers and our prospects, just to make sure that they're you know, being given the right information, because there's so much of it out there, and over the last few years things have changed dramatically. So you know, this is kind of, you know, leading into our next slide here. When you talk about some of the common vendor misconceptions and things that you're going to hear from people, the rules don't apply to us for X, Y, and Z reasons. And you know, we'll give an example at the bottom. We have until September of 2014, and that's a misinformation on the vendor part, because what that deadline is to get your business associate agreements up to date. So if you have a pre-existing business associate agreement in place, you don't have to change the language of it till 2014, but you still have to comply with the new rules this year by September 23rd. So, you know, we've even heard that with some data centers that we've worked with in the past and got them on the right track, but, you know, there's a lot of misinformation. And I'm going to use this one in particular that we unfortunately see a lot, where and this, I checked this morning just to verify that it's still on their website. Carbonite is an online backup service that's primarily used by home users, but they do offer business services.
I love this example, I have to say. This blew
yeah,
me away when I saw this.
It blows my mind.
Yeah. Please go ahead.
It absolutely blows my mind.
It's incredible.
They have a document out there that shows it's a HIPAA fact sheet, and so they're actually touting this as fact. Now, the copyright on the actual fact sheet that's on their website publicly today is 2012, and you know, as we know, all the rules changed for vendors in 2013. So they have this document out there that specifically states you don't need a business associate agreement, because that's only between covered entities under certain circumstances. That's completely erroneous, because you must have a business associate agreement in place. And in the case where you're using a data backup service, you want the data encrypted, but you also, that vendor needs to be HIPAA compliant regardless of whether their employees have access to the data or not. So by telling their users you don't need this, what they've done in essence is, come September 24th, after the deadline has passed, if you're backing up protected health information to Carbonite, technically, according to the law, you have created a data breach. You've self-created a data breach that's reportable if it's over 500 records. And you know, if you go start searching data breach fines, it gets really, really, really expensive for those types of fines. So this is one example that just freaks a lot of people out, and it's something that, you know, again, working with providers that understand HIPAA, you can't overstate that enough. It's just, they have to understand what the rules and regulations are, and by putting this out there, it's going to be interesting to see what happens if that gets pulled down before the deadline, and if they change their stance on you know, what their position is for HIPAA.
Yeah, the other funny thing about this, they clearly just don't understand HIPAA at all, because they say that the business associate agreements are between covered entities that share PHI, but with a few exceptions, covered entities wouldn't have business associate agreements, because for people who aren't familiar with the terminology, those are healthcare providers who are actually, assuming that they're working to provide care, they don't need BAAs anyway. So they are just so wrong in this statement.
Right, and this is a very large provider of online backup services, and this is a perfect example of where, you know, you get what you pay for in terms of they are a very inexpensive solution, and if you're backing up your vacation photos, it's a great solution. But for a business use, especially in healthcare that's federally regulated, where the fines can be $1.5 million per occurrence, why would you risk you know, using something that's clearly not designed for this type of application? And they've gone on record, you know, basically showing their and again, I hate to pick on a particular vendor, but this is so blatant that their ignorance to the laws and how they apply to them. It's really going to be interesting to see how it impacts their business, because you got to figure the HHS and all those people are going to keep an eye on this kind of stuff, and they've got to be aware that that information is out there. So, 2013, 2014 is going to be interesting to see what happens to businesses and vendors like this.
Absolutely, and you have to think that HHS is going to make an example of folks like this who are just, you have to say that this is really negligent, that they haven't done their homework any better than this. This is just so wrong. Love that example.
Yep.
So let's talk about a provider's risk for being audited then. What puts somebody at greater risk?
Sure. And this is kind of the crux of the problem that we run into a lot of times when we're talking with, particularly with smaller healthcare organizations, maybe one or two physicians, or particularly in the dental market where we have a very strong presence. They like to, for the longest time, it's kind of the we're flying under the radar approach. And I haven't ever run into a provider that is doing it with malicious intent, where they don't care. It's just that the perception is that the government's got a lot of bigger fish to fry, and we're so small we're not worth going after. And there's a lot of examples out there for places that have been fined for violations as small as a single hard drive or a single laptop. So what we're trying to educate people on is that your risk is more likely to happen from an event as opposed to them showing up at your door doing a random audit. Now, I'm not saying that can't happen, but the likelihood, it's kind of like being struck by lightning versus, having engine trouble. You're more likely to have problems with your car than you are to get hit by lightning, but both can still happen. So what are we talking about when we're looking at events? So a data breach, for instance, and the previous example with the carbonite is a self-induced data breach, and it comes from a lack of understanding on both sides. But that is a very likely scenario to happen, especially starting next month. You're also probably at much greater risk from disgruntled employees, disgruntled patients, and the whistleblower rule that goes into effect as well, where anybody that comes in and turns over known issues with a particular provider or facility will share in the rewards for any fines that are happening. So in essence, what the government's trying to do is create a bunch of non-payroll eyes and ears that are out there kind of watching for violations for them, and that's a much greater risk if you have those types of situations in your environment. And if we could real quick, I'll give you an example. I had one of our a potential prospect that we were working with called me in kind of a panic, and he had seen, it was an oral surgeon who had seen a husband and wife had come in for some treatment, and he put them in, the staff put them in separate rooms, and he went in, and the wife's case was going to be a little bit more complicated than the husband's case, so he had to spend more time discussing this with the wife, and then he went in to talk to the husband and apologized and explained why, and talked to him about her treatment. Well, it sounded to me like they didn't have the best intentions coming into this place, and they were looking for some free treatment, but again, this is a real risk that's out there. And they came back to him after the initial consultations were done, and the husband said, "You violated my wife's HIPAA privacy because you discussed her case with me." So for like 3 days, he was in a panic because he wasn't really clear on what the law stated. And so what I did is I provided him some information that was on HHS's website about how you can discuss, care with a spouse or family member, especially if you bring them with you to the visit. So, again, with not being informed, but that's the type of thing that is a real risk for anybody who's seeing patients, especially if they know, what these fines can potentially pocket them. So now you have other potential violations such as PCI, which is, for the credit card industry, they have very strict regulations now that they're doing a lot of cracking down on, and they're adding on to people's credit card bills, the providers for charging for credit card services if you're not compliant there. And the interesting thing is with HIPAA, HIPAA doesn't have a real specific guideline in terms of passwords. It's fairly ambiguous, and then they used the NIST guidelines kind of as a guidance for how you should do your passwords. But PCI is very specific, where it has to be a minimum of 7 characters, mixed case, alphanumeric, those types of things. So if you're taking credit cards, you have to comply with PCI as well as HIPAA. So it's whichever one is the more strict rule you have to do. And in this case, PCI would comply. So if you have a PCI violation, that could potentially trigger some investigation into HIPAA. And again, the likelihood varies on case to case. But if you're tripping red flags with one compliance sector, it could potentially trigger a HIPAA audit as well. So it's really, really important that you're working with vendors that know HIPAA and high tech, and they make it their business. You should go through your whole organization and just make a list of any vendor you work with, and then make a checkbox, yes or no, do they have any potential access to protected health information? And then, like we talked about before, a competent attorney to review any agreements that you have with any of these service providers, business associate agreements, sub-business associate agreements. And you want to make them that they're favorable to you, because you should be able to do a review or audit on any of your vendors to make sure that they're not just giving you a piece of paper, but they're actually they're doing what is agreed in this contract, because a business associate agreement is an actual contract between the two parties to provide service in a certain way. If and I don't know any practices or organizations that are not using technology these days. So again, your IT process, if you're outsourcing that, or if you have in-house, the training, the documentation, the audit trails, because the IT companies are the ones that are going to have the most direct access to protected health information in supporting the practice or the healthcare organization. So it's really, really important you have a strong relationship with a competent IT provider that specializes in healthcare. And we see this in smaller practices where they have a family friend or a relative that dabbles in technology, or they work in healthcare in some ways, shapes, or forms, and that's really just an accident waiting to happen as well, because they're not going to have the right systems in place. They're not going to be able to do best practices and audit trails, especially if this is just a hobby for them or a side gig or something along those lines, and you're more likely to have a breach scenario or unfamiliarity with how the systems integrate with one another, where the data is stored. The copier example is a perfect one there again. So you want somebody who does this full-time, as their line of business, because there's extreme amounts of risk. And we put a link up there to the HHS website for what the audit protocol would be. So if you want, when you get copies of the slide, you can click on that link and go through that audit protocol just to see what happens in terms of how an audit is conducted. And it's definitely something you want to avoid if all possible.
So you were talking about audits, and then there's audits, and then there's breaches. So and breaches will bring in that scrutiny from HHS. So how can providers avoid those data breaches?
Well, it goes back to what we talked about in our first slide, is knowing where your PHI and EPHI lives in your systems, because if you don't want the data exposed, you got to know where it lives first. And one of the things we see running rampant a lot of times is with the email systems, your communication. And rule number one is don't use a free email service like a Gmail or a Hotmail or AOL to do any form of communication that involves PHI. It's an absolute no-no. And we can go into more detail on that as far as why those services are not compliant. But there's a couple of facts and myths about compliant email systems. And all email systems are definitely not compliant, and anything that's free, you want to avoid like the plague in terms of putting it in your office and using it to communicate. And we've seen places that want to use the Google Calendars and things like that. And Google in particular, the reason their service is free is because they data mine everything. So any piece of information that passes through their servers, they are cataloging it and using it to market. That's how they got to be such a big company. They're experts at data mining. And protected health information is not something that should be data mined. And when you sign up for those services, you're basically agreeing to let them do whatever they want with any information you pass through their systems. And, again, you go back to you get what you pay for, and free never has a value to it. If somebody's giving it away for free, there's either an ulterior motive or it's not worth anything because they're not charging for it. So you definitely want to use a compliance system, and one of the things we always recommend is with in terms of encryption. And this is where there's some myths going around about encryption, that you must always encrypt patient data. And that's not true when it's inter-office communication using a secured email system on your own network or through a compliant email system. Office-to-office communication, inter-office communication doesn't have to be encrypted. Now, with that said, would I risk it? Me personally, just knowing what is out there from the fines and that, I recommend using an encryption service that will automatically detect any PHI in a communication and encrypt it for you, because you eliminate the human error factor. I personally wouldn't want anyone working for me making those decisions on a regular basis where there's fines and audits at risk. I would just assume set a system in place that's going to protect any potential private information and go from there. Now, with that said, can you send patients private information if they request it and they have like a Gmail or a Yahoo or an AOL account? And you actually can, if you get it in writing from them and keep it in your HIPAA log. If the patient is requesting it, I would strongly recommend you talk to them about the risks involved. But if they're adamant about it, you definitely don't want to get adversarial with the patient. And if they say, I want it, then just say, here, sign here, have a form that allows them to have you send that information. And as long as you're using a compliant system and sending it to their free email service, then you're covered. But I wouldn't just willy-nilly send it out there without their approval. That's some of the do's and don'ts. Email is kind of one of those things that because there's so many free services out there and Gmail is so popular, we're seeing more and more people turning to that, and that's one of the areas that there's really going to be some concern moving forward. Reviewing your vendors and their access to your systems. And again, you can do this when you're going through and making a list of who you deal with on a regular basis from technology or any type of access to the systems. Talk to them about their processes and procedures for how they allow access. Secure your systems by using things like antivirus, firewalls, and your end user training. And this is where end user training can really be a benefit, because a lot of times you'll have people that are working in your organization that may not be proficient with technology, is a polite way to put it, but they're there to do a certain job, and not everybody is a computer expert. So providing them with some basic end user training about if you get an email that has a suspicious link and what constitutes a suspicious link, and don't click on it, and this is our process for handling those types of events, you can mitigate a lot of problems before they even start by training your end users with just some basic computer do's and don'ts and putting the right systems in place. A firewall, and we'll talk about this a little bit. Going to a Best Buy and buying a firewall off the shelf, one of those Linksys home units, and sticking it in the office, that's not really going to get you the job done, because once you plug it in, it's not what I would consider. It doesn't have intrusion protection that's updated on a regular basis. Who's monitoring the logs? How would you know if somebody compromised that system? So those are the types of things where having either a competent person on staff for IT or outsourcing that job to somebody who specializes in that, these are the types of things, and putting an antivirus system in at every workstation on the servers, the tablets, the phones, any place where PHI could be accessed. Security is a big deal, and getting your users involved as much as possible in terms of training is going to help. You know, we talked about the mobile devices, remote access. That's another thing. We see a lot of people, you know, especially in healthcare today, people are working a lot longer hours, and they're taking more time at night to get caught up on their case files or putting their notes in, and they want remote access. Well, how is that set up? Who has access to it? Is there a log kept for when that access happens? You know, look at your logs frequently, because a lot of times you'll see things in those logs that shouldn't be there. And the last piece of the puzzle is data encryption. And this is a really big one. Data encryption is not required in HIPAA, but for any mobile device, if you're going to store encrypt, or if you're going to store PHI on that or have PHI on that, even if it's a single record, you want to have automatic encryption on that device, because if it's lost or compromised, it's not reportable if the data was encrypted. That's huge, because we see a lot of physicians that travel, and they'll take case files with them electronically on a laptop, and they'll go either out of state or out of the country. If that device is lost and you had the proper encryption software put on there, it's not reportable. It's not even an event. But if, let's say, you took 600 records with, that's a huge data breach, reportable, and it has to be addressed within 60 days or remediated in 60 days. And if you're in California, that actually is 5 days. So the data encryption piece, it's a very low-cost insurance policy on any type of mobile device that's going to have protected health information.
Yes, and we've seen a number of cases where people have gotten fines for something as simple as having a laptop that they took with them and it got stolen out of their car. I mean, you may think that you're being careful, but you can't predict what's going to happen, and if that device isn't encrypted and it's got PHI on it, that's a breach right there.
Absolutely.
Let's talk a little bit about the training that's required for HIPAA. What kind of training is required, and how often do people need to do it?
Sure. Well, there's a couple things when we're looking at an organization or a provider's office, and the size of the staff, and whether or not they have on-site IT resources, or if it's outsourced and things like that. But the general workforce, you should have some type of HIPAA workforce training done on an annual basis, and you want to have a record of that. So there's a lot of resources out there, and there's a lot of kind of what I would call fly-by-night resources that are really kind of low-cost providers that don't really do the job in terms of documenting, having that information available, who took it, when they took it, what their score was, or if they passed or failed, and then being able to provide you with those types of records. You want to keep all information for any type of training. So let's say you have a weekly staff meeting at your office and you discuss HIPAA. Have a sign-in sheet. Have every employee that attends a sign-in sheet, and keep that in your logs as part of your HIPAA training. But I would definitely recommend doing the workforce training. And somebody should be designated as the HIPAA security officer there. Now, you can still outsource your security to an IT provider, a competent one that works in HIPAA or works with high tech in HIPAA. But you should really designate somebody that works in the organization as the security officer, and that person's responsibility is going to be to keep all the policy and procedure manuals up to date, keep a record of all this training, and that's like your designated go-to person for this compliance and recording for the training for the staff. That's what we recommend.
Yeah, and I think it's the old saying in healthcare: if it isn't documented, it didn't happen. You've really got to document every step that you're taking to do the training and to do that HIPAA compliance. Yep. So let's talk a little bit about remote access and multiple sites. What are challenges around that, and how is it sort of increasing exposure for folks?
Sure. Well, this is where that the whole vendor understanding of HIPAA really started to muddy the waters this year. And we've talked with a lot of and we see a lot of people that are touting really cheap cloud services where they want to take all the practice information, throw it in a data center, and give everybody remote access for a really low cost, and provide like a web-based practice management system. And there's certain things that we talk about when we are sitting down reviewing this with a client or a prospect is, first and foremost, what do you know about the data center, their HIPAA policies and procedures, and how they back the data up, who has access to it, how is it secured? There's a lot of variables that go into this. So if the provider, let's say you're working with a cloud-based practice management solution, the first question I would ask them is, do you own your data centers or do you lease? Because data centers are extremely expensive, millions and millions of dollars, and to have redundancy, you need more than one multi-million-dollar data center. So the odds of a practice management provider, unless they're one of the really big ones, owning that facility is next to none. They're going to be leasing space like most service providers do. So what kind of agreements do you have in place? Now, when you're talking about that service provider that's leasing the data center, those providers may have other providers that they use to provide that service, and you see where this chain gets, it can get incredibly long, but there has to be a business associate agreement chain throughout in order to make sure that everything is on the up and up and HIPAA compliant. The next thing is, how is the security handled? How is everything logged? Who's in charge of checking that? You're basically taking your office and putting it in a different office, and you have no control over that in a lot of cases. So it really comes down to a lot of the commercials these days, especially when you see the Apple iPad commercials, they tout the convenience and being able to access. LogMeIn is another one, where you can access your information from anywhere. And as service providers ourselves, we understand the need for convenience. It's a very fast-paced world. Things change. Technology changes. Since we're on this phone, there's probably been 2 or 3 new inventions that are out that we're going to have to learn how to manage. But you have to balance that convenience with security, especially when you're a federally regulated entity. So it's not like you can just flip a switch, create a password of XYZ, and off we go. There's a lot of vetting that has to be done, and any provider that comes in and tells you they can cut your costs, and put you in the cloud in a HIPAA compliant way, I would really start to ask a lot of questions about how they're able to do that, because it's data centers are expensive, and HIPAA compliance adds an extra layer of expense to that. So you want to look at the convenience or potential cost savings on an infrastructure side. There's a lot of questions to ask. So the cloud is something you want to tread cautiously with. I'm not saying it can't be done, but if you're looking at the cloud as a cost saver, as your first item on your agenda, I would take a step back first and start asking questions about the mechanics behind that and the agreements and HIPAA compliance, and then say, show me. Provide me with your documentation. Let me see what you've got, and then start making your decisions from there.
So this is an interesting question. This is kind of a deeper dive on HIPAA. There's standards in HIPAA, and some of them are required and some are addressable. What's the difference between them?
Well, and this is another thing that we see with particularly with vendors and some of the confusion that's out there. When people see addressable, it almost triggers that we can blow that off. We don't have to do anything with it because it's not required. But addressable means that if you're not going to do it by the way they suggest, you have to provide in writing an alternate means for how you're going to handle that particular situation. And a good one for an example is when you have your practice management systems, and you leave a patient in the room with the practice management systems, and you need to have an auto log-off feature. And a lot of the times the doctors don't want an auto log-off feature because it's a pain if they turn to talk to the patient and they're talking too long and they turn back and their screen is blocked. Now they have to put their password in again. So, they go to IT and they say, well, we don't want password locks on it. It's like, okay, well, if we're not going to do that, what's our alternative? You can't leave a patient in the room by themselves ever. Somebody's got to be with them to make sure that they don't get up, go over to the computer, and start accessing other people's records. Well, that's not practical. Okay, you only have the certain number of things you can possibly do, from a practical sense. So you try to balance that, convenience again with, applying by the standards. But the addressable part is really, getting back to the main point of the slide is it doesn't mean optional, and that's where there's a lot of confusion is. Everything in the law is there for a reason, and you can't pick and choose the pieces that you're going to follow. You have to follow it to the letter of the law. So if you're going to do something different in an addressable format, you have to document how you're going to do it and make that part of your policies and procedures.
So when folks need to get rid of hardware, we've been talking a little bit about the photocopier example. What do they need to do to safely get rid of that technology?
Well, it comes down to a couple things. The technology itself, we'll take like an old workstation, for example. The only piece of the workstation itself that you have to protect is the hard drive inside where the data was actually stored on, if there was data stored on there. And I would go by the basic rule of assuming any piece of technology that has a hard drive, you just assume that there's protected health information on it. So you don't want to just, go on in Google or the phone book and pick a recycling company and have them come up and take it, and that's it. You need some type of documentation for how that data was removed and destroyed. And I'll give you an example. In our practice, when we're doing this technology disposal, there's an 11-step process that we go through from picking up the information or picking up the system, transporting it back to our facility, storing it, locking it up, documenting who has access to it, when the data was removed, and then we have 2 steps to destroy the hard drive. It's attached to a system that magnetically removes the information, and then we physically damage the drive by drilling through it. It's all documented, and then we provide the information back to the practice, the end user, wherever we got the information from. But it's that type of record keeping that you need to have again, going back to your HIPAA logbook, you need to keep track of how those machines are disposed. So just picking up the phone, calling somebody to come pick it up, that's not going to cut it. If they're going to give you certification of proper disposal, you're going to want to know how that works, who's going to have access to it, and how they document that, and what they provide you back in detail. So, the copier is another perfect example of that. Like you said, you don't think about these types of things until, somebody's brought it to your attention that the data can live anywhere. So any piece of technology in your office that could potentially store data, you're going to want to dispose of that technology. Cell phones are another example. If you want to remove the data cards that are inside them, and melt them, burn them, whatever you want to do, but document them, take pictures of that, store it in your HIPAA log. Just protect yourself so that if there's ever an audit situation, you can provide that information to prove that you have your systems covered.
All right, well, let's talk about systems management then. What do folks need to know about that?
Well, this is kind of part of the whole, working with IT and managing who has access to the information. So, like we talked about before, separate logins to the network, separate logins to the practice management system. Do you have your auditing turned on? One of the things we see a lot of times going into a new client or prospect is Post-it notes with passwords on monitors. And then they started getting a little clever and putting the Post-it notes on the keyboard underneath. So you can't see them, but if you turn the keyboard over, there's the passwords. You definitely don't want passwords sitting out. So having separate logins, but then having everybody post their passwords on Post-it notes, that kind of circumvents the whole point of having separate logins for audit trails. So, it's kind of like a go around your office and take a look and see from a physical standpoint what potential risks you have, and then go to your systems and how you're implementing that. The audit logs, how long are those logs retained? Is anybody looking at them? Because a log that nobody ever looks at, it's the same as not having a log, in my opinion, because that's the whole point of the logs being there, is to record information to be reviewed. The next big thing is Windows XP. We still see a lot of practices that are using Windows XP. It was, probably one of Microsoft's most solid operating systems they ever put out, but it's antiquated. It's over 10 years old, and they've officially announced that as of April of 2014, they're no longer supporting it from a security update standpoint. So that means it's not HIPAA compliant as of April 2014. And you don't want to start thinking about that in March of 2014, because it's a bit of work to transfer systems, to transfer data over, install new apps, get everybody up to speed, and test, and that's a big project. So you don't want to put it off till the last minute. Now is the time to start thinking about replacing those. And the way operating systems are designed today, they're much more secure than they used to be. You'll probably get a lot of people that may scoff at that, but there has been a great improvement in the security of operating systems as a whole, in the way that the operating systems were written, and you're just going to see the benefit of having new machines. I mean, chances are, if you have an XP machine, it's going to be at least 5 or 6 years old. So you're going to get that benefit for the end users having a newer machine. Also, you want to look and see if there's any home editions of operating systems. Those weren't designed to be networked or secured over a business network, so those got to go. And back to the security, do you have antivirus installed on each system? Is it updated regularly? How's that being handled? Those are just some of the pieces for good system management.
Yeah, I think people often don't think about that home edition problem, but they really need the professional edition, or whatever the equivalent would be.
Absolutely.
Well, we've got some time for questions, and we've already gotten a number of questions. I want to remind our audience that we've only got a few minutes left, but if we run out of time, Eric's going to follow up with written answers to the questions, but let's get to as many as we can in the time we've got. So here's one question for you, and I apologize because I am not technical, so I'm going to assume that you know some of this terminology that I don't, but have you gotten your PSA and RMM to sign a BAA? So we're already into acronym soup, but what would you say to that question?
Yeah, well, the PSA is Professional Services Automation, and RMM is Remote Monitoring and Management, and this is more from a vendor side. So like, we're a service provider, and those are the tools we use to provide service to our end users. So when in the instances where we review, the PSA is where we store our tickets. And there's in the ticket system, there's an audit trail and an audit log, and the likelihood of any type of PHI being stored in there, that's more of a policy and procedure. When you look at the RMM tool, which is what actually allows us to access other systems, that's where you can have screenshots, or you can have technicians that could potentially see it. And depending on how and where you use that tool, you could have PHI living in there. So I know for our particular vendor that we work with, they understand and recognize the significant risks that could impose, and they have a review committee, and they're going to have a business associating agreement in place for that. So from our standpoint, yes, I can't speak to all the PSA and RMM tools, but in our particular case, I know we're covered on that.
So here's a question that we hear from time to time. I think it's an interesting one. The question is, does the designated HIPAA security officer need to be an internal staff member of that practice?
Well, we recommend that because if you're outsourcing your security, to an IT provider, you still want to have somebody who's responsible on staff, for the training, for the documentation, for the logs and all that. And you can't really outsource that role to a third-party provider. I don't know of too many that's going to keep all that documentation and provide somebody on site to go over and review those things on a weekly basis. So you definitely want to have somebody designated as your security officer. And I would recommend putting them through a little bit more intensive training in terms of understanding the security aspect of that. So, you know, I know, shameless plug with Format Approved, that they do provide those types of services for security officers. I would strongly recommend that you have a designated officer on staff who is an employee of the organization. And depending on the size of the organization, you may want to have more than one.
Yeah, we're going to show folks some resources here in just a moment where they can get that training. And to be clear, you know, it's not that someone has to be a HIPAA expert to be the designated security officer. They just need to have adequate training to be able to track that HIPAA compliance for the organization.
Absolutely.
So one more, I think we have time for one more question real quick, and this is a question I think people sometimes get a little bit mixed up. The carbonite example comes to mind around what are the requirements for covered entities versus business associates. So the question is, does a covered entity require a business associate agreement to share information with hospitals and other medical providers?
Well, I would answer no, because that's the covered entity to covered entity example that you gave. That what Carbonite, you know, lists on their HIPAA quote unquote fact sheet. You know, it comes down to purpose and you know, need to access the information. And when you're a covered entity working with another hospital, there's a business reason for that communication to go back and forth. So you don't have business associate agreements in those things. It's business associate agreement is with service providers. So the technical description of a business associate is someone who provides service to a covered entity that may come in contact with PHI, in a nutshell. So you know, a hospital would not be a service provider as much as considered like another covered entity. So I don't think you would want to go down that road with trying to get business associate agreements in that place.
Yeah, I think generally covered entities who are sharing information providing care, as you say, they don't need business associate agreements. But
right.
It's a good question. We do get that one quite a bit. I'm afraid we're out of time. We do have more questions from the audience. So as I was saying before, we're going to assemble those audience questions and post the answers on our site from Eric with links delivered via email later in the week. I want to thank you, Eric, for joining us for today's Learning Lunch.
Well, thanks, Ryan, for having me, and it was a lot of fun, and I hope we provided some value for everybody today. You know, it's a very complex subject, and you know, we tried to break it down and give somebody you know, that might be listening at least a starting point if they haven't. Hopefully, everybody here has at least started. You know, 33 days is not a lot of time, but you know, I wouldn't panic. I would just take it from square one and start with your PHI and go from there.
I thought it was a great session, very informative. If you'd like to learn more about Eric Rieger and WEBIT services, please visit www.webitservices.com. I'd also like to thank all of our attendees. Remember that all registered attendees will receive an email with links to both recorded and PDF versions of this session. We were talking before about the training that people need. Visit formatapprove.com/education/webit/courses_security.html. I know that's a mouthful. You can see the URLs there on your screen if that's easier. To learn more about Format Approved Certified HIPAA Security Professional course, also called CHSP, which we offer in partnership with WEBIT. This course is designed to meet the needs of business associates, providing the training for the designated security officer that HIPAA requires. It also includes templates of business associate agreements, both between covered entities and business associates, but also for business associates and their own subcontractors. You get a lot of value for a very affordable price with this course, and you can get an even better value by going to the WEBIT store there. Be sure to enter the discount code WEBIT during checkout to receive a 20% discount off the retail price. That's really a great deal for you. And if you need a HIPAA risk analysis or other HIPAA services apart from training, visit the second URL on your screen there. I won't read it to spare you the long URL, but go ahead and look at that site to see WEBIT's HIPAA Secure Store, where you can learn more about risk analysis, network vulnerability, and HIPAA documentation with special discounts available. Visit formatapproved.com to learn more about our upcoming Learning Lunches. The Learning Lunch button will take you to our entire slate of upcoming webinars. Our next Learning Lunch will air August 21st tomorrow. We'll be along a similar theme. This will cover the subject of network vulnerability and HIPAA safety, so it's going to be a little bit more technical than our talk today, but I think it'll be an interesting session. Keep an eye on your email box on our homepage for other upcoming topics. Thank you again for joining us today.